Good morning, Mr. Moore.
How's it going?
All right, about as well as can be expected.
So you're doing better than Paul over there. He looks like he wants to hurt somebody.
Yes. All right, you're charged with delivery of methamphetamine and some other related offenses. So let's put your case up here. In this matter, it's alleged that on December 30th in the city of Three Rivers that you did possess methamphetamine with the intent to deliver it. That's a felony punishable by up to 20 years imprisonment and a fine of up to $25,000. You're charged with a drug double, which makes it a 40-year maximum. You're also charged with possession of methamphetamine as a drug double. You're also charged as a fourth habitual offender, which makes it punishable by up to life in prison. You're also charged with possession of ammunition by a prohibited person, and that's a felony punishable by up to 5 years in prison and a fine of up to $5,000, also as a fourth habitual offender. What I was advised is that you wish to hire an attorney to represent you in this matter. Mr. Gary Gabriel is also here on behalf of the prosecuting attorney. Mr. Gibson, what's the status here?
The defendant indicated to me that he was in the process of retaining private counsel, or he's attempting to hire private counsel, but he has I guess, an idea of who he wants to hire. And so I guess he's asking for a 2-week adjournment of the pre-exam conference to give him an opportunity to hopefully hire the attorneys he's trying to hire. But if not, then obviously I would be representing him.
Who do you intend to hire?
Levine.
All right, Ms. Montauk was just here from that firm, Mr. Marcoux and Mr. Levine. So have you actually been in contact with them?
I talked to him. Said he wants a $5,000 retainer. Well, he wanted $10,000. He said if I give him 5, he'll work with me on the other 5.
Mr. Gabriel, what's your position here?
Your Honor, a couple of things, and they're novel, and I don't expect the court to necessarily agree with them, but I want to put it on the record. First of all, I ask that the court direct the public defender to remove Mr. Gibson from the case and to assign this case to Tim George. Tim George presently represents Mr. Moore on a case that's pending in circuit court, in which Mr. Moore is charged with possession with intent to deliver. We have a motion to join that case with the case of People versus Hope Lowry. I believe next week. That motion's been filed. I don't understand the system, and Judge Stutzman has recently conveyed to Mr. Stickley the need to consolidate as we go forward into limited court space, that these cases in which defendants have multiple cases and then have multiple defense attorneys are clogging our system. So I have no idea why Mr. Stickley would have, other than this weekly system that they have appointed Mr. Moore when he already has an open pending case. And actually, we were going to go to trial this month until we found Ms. Lowry.
Well,
So
we saw the recent email from Judge Stutzman raising that issue. I try to catch it here at the district court level, and if they've got 2 different cases with 2 different lawyers, I'll try to. But you're right, the court no longer does the appointments. The Michigan Indian Defense Commission does the appointments, and so it's on a rotation. And some lawyers, they don't want the other case. At either juncture, I don't have a problem appointing Mr. George, but if he's going to retain Mr. Levine, and I don't know whether he's going to retain Mr. Levine on both cases or just this one. I'm taking it at his word that it sounds like he's actually talked to Levine and Levine. They do a lot of cases down here, as you know.
Now known as MML. I think.
Yes, it's now known as Marku, Montag, and then that other guy, Mr. Levine. Anyway, Mr. George, what's your position regarding that?
It's pretty common. I know that, I think in dealing with the prosecutor's office, I haven't had the opportunity to speak to Mr. Moore about this specifically, but generally, any type of offer that's going to come is going to be a package offer that encompasses both. It always makes it difficult as counsel to advise based on an offer when you don't know the facts of the second case. So Mr. Gabriel had mentioned that to me when he came in this morning.
Well, it may be moot if he retains Mr. Marku or Miss Montag or whichever law firm.
It's Marku that I was talking to.
Who were?
Marku,
okay.
Yeah. I was talking, my Aunt Jamie Solomon has him as an attorney. And she had gave me his phone number, and we were in conversation. She had gave me the phone, and he had talked to me about it.
All right. Well, all right, I'll release Mr. Gibson. Appoint Tim George. Set pre-exam for 2 weeks from today, which would be February. Again, we have that odd even business. February 10th. That becomes Judge Patterson's at 8:30 prelim for February 17th, 2026 at 1. Defendant intends to retain Attorney Marku. Was this a situation where this occurred while he was on an earlier bond?
Yes, Your Honor. I was going to ask the court if the court, when the bond was set, was aware of the fact that Mr. Moore is a parolee on release from prison to the Department of Corrections on parole status. This case arrived, grew out of his failure to notify his agent of the change in residence. So when they went to check on the residence, the drugs were found. He was on bond. He is on bond. I haven't filed a motion upstairs yet because I was just aware of this when I saw.
Yeah, this seems like it'd be ripe for him. Let me look at the bond was set in the amount of $15,000 cash or surety, which isn't inconsequential with community corrections. Let's see what the magistrate did. Judge Patterson did the original arraignment. I certainly believe they should have known it. Now, there's a pretrial risk assessment in here. Lifetime long criminal history pending case in circuit court on parole. Tracy cooperated drug history set by magistrate tab wedge. $15,000 cash or surety. So she was aware of it. The fact that he got charged with a new felony while he's on an earlier bond, I guess could be a matter for circuit court. Maybe he posted the $15,000 cash or surety bond, and you're subject to perhaps a bond motion in circuit court.
Thank you, Minister.
So there's a little screwy. Mr. Gibson is removed as your attorney. He isn't alleged to have done anything wrong, but we've appointed Mr. George, who has your other case. So Mr. George now represents you in your pending circuit court case and this case, which is set for a pre-exam conference in 2 weeks. In the meantime, if you do hire Mr. Mark, who he can file an appearance, and Mr. George would be released from whichever case he appears in. You're under pretrial supervision. Are you meeting with the community corrections agents?
Every Thursday.
All right, you need to keep doing that. It won't take much of a blink of an eye to put you back in custody. I don't know why your parole agent didn't pull the pin on this either, but at this point, you're on bond, you've made your court appearances, you're in compliance with community corrections. And it's set for 2 weeks from today, February 10th at 8:30. Thank you, Mr. George.
Does the court want a substitution for the file?
I don't know that we'll need one. We'll just do an order.
Okay. Thank you.
Thank you, Your Honor.
And the logistics of that, Mr. Jabry, I don't know if I'm ordering MIDC to appoint him.
Technically, in order to comply with the statute, basically, yeah, you're indicating to the Vigilant Defense Attorney, Chief Public Defender, that to expedite justice. We're just gonna run into some real issues going forward, Your Honor. I'm sure you guys are too.
Yes, like I said, I had more leeway when I was doing the appointments. And I would often, hey, oh, you're here, will you take this other case? Or just say appoint so-and-so.
Sure.
But it certainly does make life complicated for everybody, including the defendant, when that happens.
Yeah.
All right, Mr. Gibson, let's keep plugging away here. We've got Travis Gentile. He's asking for an exam. And did we decide what we're doing of Brandy Green?